All right. Well, thank you everyone for tuning in and joining us again for the next edition here of the Moving Beyond the Coronavirus Economy series. And if you've got a better name for us to transition to, we'd love your suggestions. So please fire away, send us a note, send us an email. My name is Tom Dufour. I'm the founder and CEO here at Big Sky Franchise Team. And if you're new to this session or the series that we've been doing now for about 2.5 years, we do these are educational sessions to help educate you on timely issues that are happening real time right now that impact your franchise system, that impact your individual, maybe as an owner operator and running your current business. But these are practical things for you to take and use and to help educate you, to help grow your business and grow your brand and make it better. And I'm thrilled to have on with us today Alan and Brianna with Universal Background. And I've been a customer of Universal Background for many years. When I owned my franchise, you may have heard me if you've tuned in the past, speak about my franchise in the past that I owned, and it was an industry with a very high turnover. So we were regularly running background checks, and I'm a satisfied customer. So I'm happy to give that testimonial and share my own experience in working with the organization. But Alan and Brianna are going to share with us some great information and timely, I think very, very timely information about some changes and things for you to be aware of as the owner of your business. So with that being said, I'll turn that over to the two of you to take it away.
Great. Thank you, Tom. And thank you all for the opportunity to present to you all today on how to reduce hiring risk. We're going to be going over a couple things, answering your questions and information. First, I'll introduce myself. My name is Brianna. I am one of your dedicated account executives for the partnership, as well as Dr. Alan Lasky. Alan?
Sure. Hi, everyone. Thank you for joining us. I'm Alan Lasky. I'm one of the senior vice presidents here at Universal for the last 12 years, but 20 years experience in the industry, focused on franchises more than anything else over the years, and actually come from a franchise family. So, very familiar with the types of challenges that occur, especially in this new economy after COVID or during COVID. And so we're going to talk about that. But, what we focus on a lot is compliance and how to reduce risk, because there's so much risk out there that we're going to go over. And hopefully that will cover all of the types of challenges that you see if you're doing employment screening, and why to do employment screening. So we're going to cover that today. So thank you for your time.
Great. And before we begin, we'll go over a few items about who we are as a partner of Big Sky and a little bit about Universal.
I actually need to share the screen, but I can't. Okay, here it goes.
Perfect. And so just a little bit about Universal. We've been in the industry for over 50 plus years now. I'm very proud of the fact that we've been voted 12 years in a row as #1 enterprise firm overall by HRO Today in a client-based survey. We are one of only 7% of accredited firms in the US, and we really strive to give personalized care. We're compliance driven, and we are in all time zones, and we have 24-hour assistance. And this just shows there are a lot of increases in litigation right now. So it's always good to reduce risk, which will help protect your brand.
Yeah, we're seeing such a heavy increase in litigation, and we'll talk about that. And there are ways absolutely to reduce that risk very easily, just about some of the things that we're going to be going over the next few slides.
And this just shows the risk level. So a study of 1,000 in-house counsel and HR professionals ranking the most challenging issues that they face. And 2 of the top 5 challenges are things that we handle. So background screening, marijuana laws, drug testing, those are all things that we handle here at Universal.
And to start off with, to talk about when you're doing any type of background check, it's all under the federal law, and it's called the Fair Credit Reporting Act. So anyone, if you're doing any type of background screening under federal law, which was started in 1970, they created a law in the government to ensure accurate information is reported, to limit what type of information can be reported, which has changed dramatically over the last few years, and also to provide a dispute mechanism. And that dispute mechanism is really important because the courts admit that they don't have all accurate information at the courthouses. And especially if they're a manual courthouse, they may have a manual process that they miss something. So every candidate has a right to dispute their information, which we'll talk about. And when we're doing background screening, any consumer reporting agency, which we as Universal are one of the many background screening firms out there, we're all under the, we all are under the Federal Trade Commission. And the Federal Trade Commission about 20 years ago started the Consumer Financial Protection Bureau, which is their division that audits heavily the background screening industry and their clients, as well as the EEOC. So the EEOC making sure that there's no discrimination, which again has been in a lot of lawsuits over the last 10 years, which we'll talk about. This is just a recent, in the last year, article that came out about how the FTC and the Consumer Financial Protection Bureau are being very, very strict now with background screening firms and their clients to make sure that things are fair, equitable, non-discriminatory, and following the right proper procedures. There have been too many cases that you can read in the news about procedures not being followed properly for an employee screen that has ended up in this purple graph, which are federal complaints and litigation. As you see, it's increased dramatically over the last 10 years. The green graph is interesting, and we're going to provide you these slides too as a resource. We do have the resource down here, and the Consumer Financial Protection Bureau on the government website has a link to file any consumer complaint that you want from a consumer reporting agency. And there's right now 2.95 million complaints. It's a good barometer for background screening firms, and we're very proud that we have 0, but you can look up anyone on that as a consumer reporting agency to see how many complaints they have. It's a very good barometer, and the government is highly encouraging candidates, your candidates and the consumers, to file any complaint against any organization so they can have whistleblowers. And, you know, part of that is the reason why class actions have risen in our industry, which has become very litigious. A third of the US population, over 100 million people, have an arrest record, at least. So with that known, there are so many new laws to protect those that may have had a arrest from a long time ago, to give them the right to at least be thought about for a new job position. And so we'll talk about that and what that looks like. The laws are also becoming much more fragmented as a trend. So we're seeing more municipal laws than ever before. Before, it was just a federal law and maybe a state law. Now it's at the municipal level or the county level, which has made it very complex to follow all these laws in the areas you are, whether you have multi-units across multi-states, or that you have you are in different states, or just even in the state you're in or the county you're in. And these increase in settlements over the years, I mean, I started 20 years ago in doing this and following all the litigation. It used to be very, you know, in the tens of thousands of dollars. The damages now of these cases, that one of the most recent larger cases was in July for Spectrum, which was a $7 billion verdict. I mean, it's now in the billions of dollars. And the problem of how it affects you is that this is now case law. So if there is a case in this case, there was actually not a background check done when there should have been, because it was a home worker. And because of that, because of no background check, it's now case law that if there's not a background check, it can end up in litigation in the billions of dollars. So that's the concern of how it can affect you. In addition, you know, we get this question a lot from a lot of franchise organizations of why can't I just go on and just do a background check of one of those websites that are online? And the answer is because if you read the fine print, it says that they're not a consumer reporting agency. They're not following the proper procedures for an employee screen or a consumer report screen. It's really for entertainment purposes of those that are online, and they've all been sued for millions of dollars, which is why they have to put that notice at the bottom. This is a real example of one. So you always want to just make sure that you're with a background screening firm that is a reputable and accredited firm. It's very important. It's also important to know, you know, what can be reported. So behind the scenes, when you do a background check, if it's of a criminal nature, by federal law, we can only go back 7 years of negative information across the nation. So that's if it's an arrest and non-conviction. If it's a conviction, in most states, we can go back as far back as possible if it's in the court record to report it. And we always want to report everything that's reportable by law for you to make the decision and determination if you want to hire that person. What's important to know too is that there are 9 states that actually have their own state laws. So what's important about this is where it becomes tricky, and then the background screening firm should be doing all this vetting for you behind the scenes before you obtain information, and not all do. And what I mean by this is that if you are at the current time in Texas, but at the same time your candidate at the time of hire resides in California, you see California at the top, we can only report 7 years of information and conviction only information. So we as a conservative approach only behind the scenes use where the candidate resides at the time of hire and where your organization resides. So we use the most conservative approach in this graph to make sure we're only reporting reportable information so you don't get sued. The last column, the exemption column, is really interesting. So there are certain states that have state laws that if you make under that amount, we can only go back past 7 years. If we make more than that, if that candidate makes more than that amount, we can go back past 7 years. And if we don't know, we default it to 7. It's just certain salary laws. And so if someone's working part-time, you have to be very careful about that, but we're always going to default it to 7. And so should your background screening firm if you're using someone. Something really interesting happened recently, just because we stay up on the laws and litigation. Just this month, Amazon got sued for refusing to hire a sex offender who had a sex offense for over 7 years ago in California. Unfortunately, as you see here in this graph, you cannot report that information. So both the background screening firm and Amazon are going to have a hard time because this will become a class action lawsuit, or at least a lawsuit for millions of dollars. So you always want to make sure, as a caveat, to just make sure that your background screening firm is reporting only reportable information that you receive. And to talk briefly before we move into more of the trends in litigation that we see and how to reduce it. So when you do a background check, no matter what type of background screen you have, you should always be consistent with the type of search that you do for the certain population you do it for, and keep it standardized. But what's also important to know is that usually when someone wants to do background screening, they think it's just a county or state level, and with a social identifier, social security trace, to find out who that person is. But what's important to know is that even beyond kind of the surface level of background screening, there are federal districts that don't report to the state counties and states. So you can do a federal district, and there's 94 federal districts in the United States that report information like racketeering, mail wire fraud, credit card fraud. And if you want to know that information, you have to add that as a layer to the background check package. There's also supplemental databases that are, a national database. They're not exhaustive, but they have information in them. There's also employment and education verifications to do. You can do them in-house, or you can have a background screening firm do them. And of course, motor vehicle and other industry-related background screening, depending on your industry. You can always consult with your background screening firm. We do all the time with our clients of what they're looking for to build a package for them that suits them. It's important to know too, but certain states and certain types of positions are mandated to do fingerprinting. For instance, Florida has a lot of different type of positions that are mandated to do fingerprinting, especially in healthcare and education. What's important to know about fingerprinting, which is really interesting, is though it's through the Department of Justice and State Police. Back in 2013, the National Employment Law Project did a study, and they found that 25% of all criminal information is missing in a fingerprint, and 50% of all final disposition information is missing. So it is extremely faulty, our fingerprinting system in the United States. And in fact, the FBI admitted to the fact we're only as good as the information that's reported into it. There was a few years back, Virginia admitted that they were missing 750,000 records in the fingerprint. So if fingerprinting is mandatory, it's always important to still do a supplemental search, a smaller search with a background screening firm, just to make sure you're covering everything if you want to make sure that you do your due diligence on a candidate. As for what we see for trends in the industry, one of the biggest ones that we're concerned about is the amount of expungement of information in courts. You see the states that are listed here, which may affect you depending on what state you're in. These states are already starting to redact and remove information from the counties, so you can't see if someone had a case. And we're really concerned about that as an industry, and we're lobbying against it because, sometimes misdemeanors can drop, or excuse me, sometimes felonies in court can be dropped to a misdemeanor in a case. And if it's dropped to a misdemeanor, and if all misdemeanors now after 7 years are removed, then that felony that was an actual felony at the beginning is no longer in that report, in that court record. It is a concern of ours, and we're lobbying against it. But as you see, these states are starting to remove information that we're lobbying against. So as the employer, you should have the right to decide who you want to hire or not, even if you see that they have a case.
Alan, I have a question. Sorry to
please.
interrupt just
No,
on
please.
this. So for these, what would be making a state want to remove this information, especially for a background check? I mean, I think of in the franchise world, as you all know, home services has been surging.
Absolutely.
And I know for sure, I used to own a home services franchise that, generally speaking, you in the business I was in, it was generally a male technician going into a home that had a female resident present. And if there's some kind of felony of some kind, like, she's going to probably want to know that our technicians were background checked. So
Right.
I'm just curious to know, like, why, what the driver is for this.
It's just because a third of the US population has some type of case. We get
Mm,
the fact with arrests as opposed to convictions, but the pendulum has swung now where courts are just removing everything after 10 years, some of them, as well as looking at the cases to what they can remove. And they shouldn't have the right to do that. If those cases are in there, it should be decided about the employer to make a determination if it's job related, which we'll talk about in a minute. But you know, unfortunately, this is what courts are doing, and we're fighting against it to say it could lead to some real devastating actions. We've seen 4 cases of murders at in-home types of organizations that are in the news that we have those articles of. And it's just so crucial to make sure that someone is not of a violent nature or a theft nature if they're going to be going to people's homes.
yeah. Well, and I would say, and sorry to interrupt you there, but
No,
I'm
please.
just thinking
More
of these
questions,
kinds of
yes.
businesses, really, the violent crimes and like theft, those are going to be, I would imagine, the big concerns, especially
Exactly.
for that, for the homeowner or even a commercial property owner. I mean,
Exactly.
yeah.
Absolutely. And that's what we're hoping is not removed, but they are removing information that is of a nature that you'd want to see. So we're fighting against it, but these are the current states that are doing it. The other interesting trend that is changing, fortunately for the better, is that first Michigan, then California decided to start redacting information, removing private PII information from records. As a consumer reporting agency, all consumer reporting agencies have to have 2 identifiers. So we have to have the name, because that's what all court records are kept by, first, middle, and last name. But then when we find the dockets for those or the court records for those, when we pull them, then we have to double verify them for the date of birth, the social security number, and the addresses to make sure that we have a match. If we don't have the driver's license number or date of birth information or social security number, we can't match that person and we can't perform it. So California and Michigan started removing information, so we couldn't even report as an industry anything in those courthouses. Now, fortunately, we lobbied against it so rough that we actually got the state of Michigan to overturn it with the governor. We're now finishing up in California, where now there's a bill, even though it's still enacted, to remove information in certain courts like Los Angeles and Sacramento and other areas, where the bill 1262 was passed by the Senate, was passed by California politicians, and now we're waiting for the governor to sign it, and it'll go into effect the 1st of next year. So what's good about that is that they cannot remove information anymore, and we hope no more states try to do this. Because you want to know if someone did something in accounting, the worst thing in the world is for us to get back to you and say, we don't know, we can't perform it because the county won't let us. So fortunately, that's going away, and I think that trend will stop now.
Okay, thank you.
You're welcome. This is probably one of the most important slides. And again, when you get the slide deck, the link is up here to the guidance factors. So back in 2012, the government decided to make these guidance factors, which are really requirements. They're really law. And it's to look at each individual at a case-by-case basis, the nature and gravity of the offense. Is it a person that's a repeat offender? What's the severity of the offense? Is it job related? To use all those to make the determination each individual. And a lot of the new laws that are coming out about ban the box, which is that question, have you ever been convicted of a felony or misdemeanor, that you can put in an application. There are now laws all over the place in the United States against asking that until a conditional job offer is made. But what they're doing, the laws, they're putting additional statutes in about these guidance factors. So they're making them laws. So it's just really important to follow this, to not make any blanket policies in a marketing article saying we don't hire felons, which I'm sure none of you do, but it's just important because it has gone to litigation before that will end up in court because of these guidance factors, and just to look at each individual a case-by-case basis. That's what the government wants you to do. And not to spend a lot of time on these next ones, but to mention them because we do have the links. To ask about a person's salary is now becoming very tricky because 21 states ban the ability to ask until a conditional job offer is made. So if you did ask, it can end up in court by you asking how much they made at their last position. Whether it's by email or verbal, it's not allowed in these 21 states. And we have the links of which states they are. As you see at the bottom, there are 2 cases already that are case law where someone did ask and then ended up in a lawsuit that was settled. So again, just to be sensitive to the fact of how you ask that is really important, and to know your state laws, which we have, again, the salary ban laws here. In addition, just in general, always, like I said before, standardize the process of the type of job position you want to do a background check for, and have a reason of what you're running for that job position. As long as you standardize it for your firm or the job position that you're doing, even if you have 5 different packages for a driver and for an admin person and for a manager, which would be 3 packages, as long as they're standardized, it protects you against perceived discrimination or discrimination. And your background screening firm can create those packages for you. In addition, very important, you can see all the different types of organizations that have been sued in the millions of dollars for not doing this right. Anytime you're doing a background check, you have to have a disclosure and authorization form signed, which your background screening firm should provide you. Again, they should have the proper language on it. There should be no extraneous language added, so you can't add additional language to that information, because it has to be written exactly the way it is. And you have to have them sign it before the background check is conducted, which can be the electronic, which we have for our clients. And you just want to make sure, again, that it's signed off and they get a copy. It should not be stapled to the application, and it should not bleed into the application. That's what this means solely of the disclosure and authorization. They have to be separate forms. It's ended up in litigation, believe it or not, just for that one purpose, that supposedly it's confusing if you add it to the application. So you want to keep them as separate forms, which we do for our clients. In addition, besides those disclosure and authorization forms, there's a summary of rights document. So anytime you do a background check on someone, you should give them the government form that says what their rights are. It's a form, we have the link to it, but as our electronic automatically gives it to them in our e-form process. But you just want to make sure that they have their rights. It's a simple form that's online, and we can easily give it to we give it to our clients to give to their candidates. In addition, the last type of form is called adverse action. And that's what we were talking about at the beginning, where you have to give the candidate a right to dispute negative information if it influences you to not hire them potentially. Very important. No matter what company it is in the United States, everyone has to give the candidate a right to dispute that information before they rescind the offer. And there's 4 easy steps, and we have them for you. We'll give you these slides again. You want to notify the candidate. So let's say we have a candidate who has a 2 violent crimes, and we're not going to potentially hire them. We give them a copy of the report. Also, this adverse action letter that your background screening firm will provide you that has language on it saying we may not hire you. Again, a copy of the report and that summary of rights document that we just talked about. At that point, we have to wait a reasonable amount of time. That's what the government uses, the term reasonable, which is anywhere between 5 or 10 business days is what the government says, to then take the next steps. Now, during that 5 or 10 business days, the candidate should have an option of disputing it, which the background screening company would handle for you and communicate to you and the candidate until it's resolved. If in those 5 to 10 business days that you standardize, they don't get back to you or us, you can then send the final adverse action notice, which is a template, a copy of the report again, and that summary of rights document. Now you can rescind the offer, and now it's protected. If you follow these steps, if it ever went to litigation and you follow these steps properly, it always holds up in court. If you don't follow these steps and you just fired someone based on seeing a violent felony, but you never give them a right to dispute it, they can actually go to court and win or bring a class action, which is why these steps are so important. And we're always trying to answer more questions about this process. And if there is a dispute, we will handle this dispute process within 5 business days or less, even though the government says that you have to wait 30 days to open that requisition, which no one can in this market. You need to get people hired right away. And
Alan, just a couple questions on this section before you jump into where you're headed here.
sure.
One is for the adverse action and really for the paperwork that gets filled out. How do you help your clients fill out this stuff or guide them or give them the right forms? Is this all part of your process that you go through with them?
Yeah, thank you, Tom. We do. So we actually have on our site ability to fill out templates if for free. Or like, for instance, for a nominal $350, we do it for them. We send out the letters, we put their logo, the logo of the organizations on it. We track it on the report. We then send a tickler of how many business days they want to wait until we send out the final. And then we send out the final with, again, these 4 steps. And we mail it out and we date and time stamp it. So everything is documented. But we actually provide that. Every background screening firm should provide some type of solution. We have a very easy solution for our clients that is tracked, so it holds up in court.
Great. And I don't know if you plan to talk about this, but just in terms of background screening, not only in addition to the candidates that are coming through as prospective employees within an organization, I'm thinking of in twofold. One, and both from the franchisor vantage point. The first is, as a franchisor, when they onboard franchise candidates or look to bring on a new franchisee
Absolutely.
into the system,
Absolutely.
many franchisors will have a background check conducted as part of that kind of final due diligence, or it may be intermingled or mixed in, I should say, with the franchise qualification process. So how do you work in those scenarios? I'm sure someone who's going to listen to this and tune into this will be thinking, well, how do I do this or use your service for when I'm onboarding new franchisees?
Absolutely. And thank you for bringing that up. So we have different markets that we do conduct background screening for. One is, of course, for employees, but also for franchisees. So it's a different package because we can do more financial, making sure that they can take care of the obligations of owning a new franchise, as well as their criminal and background. So it is a different package when we do franchisee screening, but we absolutely do it. I've been involved in franchisee screening, seeing some potential franchisee owner that put a hit on a previous partner, where, of course, they didn't hire that franchisee based on a real violent past. So it is extremely important. And besides the financial part that we can do for franchisee credit, and looking at bankruptcies, liens and judgments and those types of things, it's extremely important to definitely know who you're bringing on as a franchisee on the front end. So we absolutely do those types of searches too, and help consult build those packages.
Great. And just from the franchisee background check, it sounds like I was not as familiar with your service for doing also kind of that financial checkup or verification, I should say, for the franchisee coming into the system. When do you see or recommend that this background check for a franchisor to conduct on an incoming franchisee? When do you generally see that happen, or when do you recommend that a franchisor conduct that?
Great question. And it's around the time when you're going to make the conditional offer. It also saves you money too, right? Because first of all, by knowing that you're doing a background check on them will scare some away if they know that they have something egregious on their record that is just not going to. So you save yourself time with them knowing that a background check is going to be conducted. The second thing is that with all the laws that we see as a trend, it's best to wait till you are making that conditional, around that conditional time, definitely after an interview and you have your final grouping.
Right.
That's really the best time to do it. And realistically, the turnaround time of these background checks are anywhere between 2 to 5 business days. Usually more on the 2 sides, 2 or less for just criminal oriented searches. But when there are verifications that take a little longer due to COVID and limited employee staff at these locations we call to verify, or schools, or with credit and the review, it can take a little longer, but usually between 2 and 5 business days for a franchisee screen, as opposed to a candidate screen, which usually is 2 to 3 business days tops.
Yeah. Okay, that's great. And then in terms of a franchisor, um, most franchise manuals that we produce or work or have seen over the years for clients from clients have background checks as part of it, because they're maybe going into someone's home. There are various reasons. Maybe they're working with kids. Background checks are required. So how do you work with franchisors in terms, and you may be talking about this at the end, so please hold off, but I'm just wondering how you help franchisors work with franchisees in making sure that they're properly going through appropriate, like all these steps you're describing. There are a lot of steps here. It seems like you could maybe make a mistake on. So how are you helping the franchisor help the franchisee, I guess?
Sure. We actually work with them on doing a presentation for the population they want, whether it's all their franchisees doing the same thing. And when we set up a new client, we go over the steps of where everything is and what everything is. Then we do compliance webinars like this 2 times a year to make sure that our clients understand what's going on for our clients. And we're always around to consult with what goes on or what's going on in the industry to help reduce risk.
Okay, great. Thank you very much.
Absolutely. Thank you for that. And, a big one that we're talking about now too, which relates to consulting quite a bit, the new marijuana laws. And not to read all these, but just again, because we'll provide these slides, what we're seeing as a trend, and these are some of the new states that have new state laws of the last year. Most of these trends of the marijuana laws are now pointing as a trend to making sure if you're going to have a marijuana check in your drug test as one of the panels, that they're tested positive during normal work hours, which is tough. So if you're doing a test on a weekend and someone tests positive, there's a lot of states that say you can't use that information because it wasn't during work hours. So it is becoming more tricky, and we're getting a lot of clients moving from, if it's a 5 panel, which are the illicit drugs, they're moving to a 4 panel, taking the THC out. And if it's a 10 panel drug test that has the illicit drugs and the abuse of over-the-counter prescriptions, we're seeing not a 10, but a 9, taking the THC out. So as a trend, with all these different states that have state marijuana laws, we also have a link to all the marijuana laws that are updated down at the bottom here. But what we're seeing is that if they're safety sensitive jobs, you'd want to define them as safety sensitive. If you have drivers, for instance, and they're going into people's houses and there's something that is that could be a danger to themselves if they're under any type of influence, that's important to put in the job description as safety sensitive with your legal. That will add a little protection. In addition, again, just know your state laws. We're always around to consult about that too, in case there's a question about it. And we do that almost daily now, just because of all the laws that are changing, of all the states here that you see on this graph that are turning green. So it's just really important. If drug testing is used, it's still federally that you can do a drug-free workplace policy on a federal level, but all these states are changing their laws, and even municipal laws. So it's important to know your laws on this. Last but not least, we have about the ban the box. This is a huge question too. I talked about it a little earlier, that question, have you ever been convicted of a felony or misdemeanor? Before, years ago, right, you can ask that question on an application. No problem. Now, 150 municipalities in the United States and 37 states have their own laws. They're very, very specific, and most of them all point to, again, after a conditional job offer is made, you can ask that question. So that's really, really important as a conservative approach. If you are going to ask that question, wait until a conditional job offer is made. That you'll protect yourself with all these states. We're also seeing in these states that adverse action process of giving the candidate a right to dispute, there's actually a few municipalities that have just unfortunately tacked on a little statute on some of these other laws that is a separate law that says, hey, with adverse action, also send it out and give them 5 days to receive it, and 5 days to dispute it. Now they're actually mandating it to be 10 business days to wait. So there's only a few municipalities. We do have a resource down here that you can click on and see the different state laws that are out there. You can also type your state followed by ban the box state laws to see what your state laws are. And we're always around to consult on that as well. Because these laws are changing and you just want to make sure that you reduce risk by doing these things that we just talked about. Any other items that we could go over or cover that you feel would be helpful?
Well, I had another question that came
Please.
up in the section when you were talking about I made some notes just on the states rules and the state changes, and really talking a lot about it. And it really reminded me a lot of the franchise rules at the various states. So there's the Federal Trade Commission regulates franchising on a federal level, and then all the various states have all these different, their own little nuances, right? And some states are similar, some are kind of on their own, doing their own thing. And it sounds like what you're describing in for the background check situation, that it's very similar. What would you say to that kind of an idea?
I would. I mean, we're seeing, working from a franchise family and seeing the laws change too within that franchise, which was, which is, I get can be very frustrating. We're seeing the same thing in our industry, which is really frustrating. I think it's changing the same way where there's just more and more provisions. And a lot of it is, the domino effect of, because the Federal Trade Commission is making more laws, it makes organizations make more laws as well to try to protect the organization, the brand. So we get the fact that that's happening, but sometimes it becomes really stringent to the point of where it becomes a challenge to, again, work through them or around them as obstacles. That's what we want to help navigate, because of the fact of how many laws there are out there that are local, which again, it has never been the case. As Brianna brought up at the beginning of this, out of the 5 top challenges that HR or in-house counsel and HR representatives are finding out of 1,000 people they surveyed, 2 of them are pertaining to background screening and drug testing because the law changes. Besides the others, of course, that are challenges that we know that are outside of us, quite a few. But we want to help out with any way to reduce that risk with what we can do, and are known to help reduce risk, and are proud of the fact we don't have any litigation, and we are not on the Consumer Financial Protection Bureau's complaint site. So that's our litmus test to making sure that we're protecting our clients, and we're always around to consult and help out with any of these types of challenges or items that you see out there.
Great. Thank you. And just by way of how a franchisor could work with you in terms of as either a preferred supplier, or do you have like preferred supplier
Sure.
programs, or
Absolutely,
or for
So-
just a one-off business?
absolutely. So we understand the preferred relationship as opposed to the required relationship. We have franchise organizations that do both, one or the other. Preferred is great. I mean, what's nice is that there's no money at all, as opposed to just creating a program that has a consortium-based price discount for the whole organization. If they're interested, we go over the different sample packages that we set up initially for the organization, plus a la carte items. And then we consult with maybe what is needed by an organization to do a specific package. And there is no upfront fees. So we waive all fees. Brianna would be the point of contact to help out with setting that up, as well as myself. And what we do is we just set up the account with no money up front. It's just creating the packages and pay as you go. That's a net 30. So we make it very easy. Besides, again, training and consulting and providing the right forms, the proper forms and procedures. So we help set up that program.
Great. And how do they get in touch with you all to do that? What's the best email? Can we
Sure.
maybe type it into the chat? Oh, here we go. Perfect.
Sure. So yeah, but Brianna and I both work together. And again, the only difference is that hers is Brianna.Brewington. But if you send it to me, I would send it to her and include her on for both of us to help out. And again, provide you the information you need. Again, it's non-intrusive. We'll answer any questions. We just want to be there for help and assistance in any way we can.
Great. Great. Well, do we have any other questions from our, I totally monopolized questions here, so I'm sorry. It got me thinking as we were going through. I'd love to open it up to our attendees who have been hanging on here. So thank you all.
Thank you.
If you have a question, hit the raise hand feature or type it into the Q&A or chat session here. And we'd be happy to go through that. So we'll wait a moment. All right, I'm not seeing anything start to come through here. So, Alan and Brianna, I'd just like to say thank you to both of you for your time, and to Universal Background for helping produce and provide this great information that you shared with us today. We're so grateful for it. And as a closing thought for anyone who maybe you came in, you joined a little late, or you'd like to get a replay or share this with someone, we generally have this rebroadcast within about a week. We'll have this republished and available on our YouTube channel, as well as on a replay podcast channel as well. So thank you both very much for being here.
Well, thank you. We appreciate the time and opportunity, and we're always around to help out and provide information at any time that you need assistance. So thank you for your time and have a great weekend.
Yes,
Yeah, thank you
Tom.
too. Thank you. Take care.
Bye.